You're grieving a parent, managing funeral plans, getting your siblings to stop arguing, and then someone says, "We have a will."
But we still have to go to court.
What? I get this call all the time. Rachel, my mom had a will. Why are we in probate? And if that's your question, you're not alone. Today, we're going to bust one of the biggest legal myths in family law that a will avoids probate. It doesn't.
But don't worry. By the end of this episode, you'll understand exactly what probate is, what a will does and doesn't do, and how to protect your family from unnecessary courtroom chaos.
Welcome to Gavels Down, Voices Up, where we flip the script on conventional legal discussions. I'm Rachel King, here to guide you through the murky waters of estate conflicts, inheritance disputes, and all of the dramas. We're not just talking about law, we're talking about how it affects your life, your rights, your future, and your money. From the courtroom to your living room, we bring you insights that matter. Dive into each episode ready to challenge, learn, and grow. Ready to change the dialogue. Let's begin. Gavels down, voices up.
Probate is the legal process the court uses to authenticate a will, if there is one, appoint someone to be in charge of the estate, make sure debts are paid, and distribute whatever's left to the rightful heirs. In California, probate is public, procedural, and mandatory if the estate is valued over a certain dollar amount. Currently, $184,500. So think of it this way. Probate is the courtroom door that families have to walk through when someone passes away with assets in their name. And yes, even if there's a will, we still go through that door. Here's the big shocker for most people. A will does not avoid probate. In fact, a will is basically a set of instructions for the probate judge. Let me say that again. A will says, here's who gets what. But the probate court still needs to approve, supervise, and enforce it. So, yes, even if your mom had a beautifully written will in a leather binder with gold lettering, the family still has to file it in probate court. And the process can take anywhere from 9 months to 2 years, depending on the county, court backlog, whether anyone contests, and how organized everything is. Now, if there is no will, the process is still called probate, but it's handled under something called intestate succession, which is just a fancy way of saying the state decides who inherits. Either way, it's a legal process, and it doesn't automatically go away just because someone filled out a will. Great question. If a will won't do it, what will? So here are the top ways to avoid probate. First, living trust. This is the number one tool to avoid probate in California. If all your assets are in a trust, they pass privately and quickly to your beneficiaries. No court, no long process, just clean transfer. Second, beneficiary designations. Think life insurance, retirement accounts, and even some bank accounts. If there's a named beneficiary, those assets pass outside of probate. The third one is joint ownership. If you own a home or account jointly with right of survivorship, the surviving owner gets the asset, no court required. And lastly, small estate affidavit. If the total estate is under $184,500, you might be able to avoid full probate through a simplified process. But be careful, one house in Southern California and you're over that cap. Here's what I tell clients. If you want privacy, speed, and lower stress for your family, build a plan that keeps you out of probate court. Let me tell you about a client. We'll call her Anna. Anna's mom passed away with a simple will that said Anna inherits the house. Great, right? Except the house was in mom's name only. No trust, no joint owner, no transfer on death deed. So even with that will, Anna had to go through 15 months of probate, spend over $5,000 in court and legal fees, and face delays at every step. She told me later, I thought I was doing the right thing by having a will. I had no idea it wouldn't be enough. That's why I want you to know better. A lot of people ask this, and the answer is both. Here's why. Your will is your backup plan. It kicks in for anything you forgot to put in your trust. Next, your living trust is your primary tool. It holds your assets and keeps them out of court. Third, your powers of attorney and advanced healthcare directive round out your full plan. Wills are helpful, but they don't replace a trust. And neither replace a smart legal strategy tailored to your life and family. Okay, let's recap.
A will does not avoid probate. Probate is a legal process, not a punishment. But it's often slow, public, and stressful. There are ways to avoid it, and they all start with proper planning. If you've ever said, I just want to make this easier on my kids, then now's the time to act. Talk to a lawyer, get the paperwork in order, and protect your legacy. You deserve peace of mind, and your family deserves clarity, not courtroom drama. Thanks for tuning in to Gavels Down, Voices Up. I'm Rachel King, reminding you to speak up, plan smart, and remember, every voice deserves to be heard.
That wraps up another episode of Gavels Down, Voices Up. If you found value in our discussion today, please subscribe, leave a review, and share with someone who needs these insights. Your engagement helps us grow and impact more lives. I'm Rachel King, thanking you for listening and reminding you to speak up, because every voice deserves to be heard.